S.S.T. College of Arts and Commerce. I am Dr. Padma Deshpande. On behalf of the Student Management Council and the Department of Management Studies, I welcome you all for this national webinar on patents rights. Patents, copyright, and trademark are the different forms of intellectual property rights. To know more about this session, we have a special resource person. But before introducing the resource person to you, I would like to wholeheartedly thank the college management and our founder principal, Dr. J.C. Purswani, and the IQAC coordinator, Dr. Khushbu Purswani, for always encouraging us to arrange such kind of sessions for the benefit of the student fraternity. As I said, patents, trademarks, and copyrights are different formats of IPR, that is intellectual property rights, which have different usage and which are issued as per their usage. To tell us more about these patents, copyrights, and trademarks, which are usually issued for inventions, art and literary work, and for slogans, then the trademarks are issued for brands, etc. So to tell us more about this, we have a very experienced person in the form of Dr. Bharat Suryawanshi. Sir is the Assistant Controller, RGNIIPM, Government of India, Nagpur. Sir is in service since the last 20 years with Central Government Patents Office. Sir has a PhD in bioefficacy and cytochemical, and Sir has trained hundreds of judicial officers at the national and international level. His special achievement has been given by giving a landmark judgment by rejecting the Pfizer patent application for arthritis drug. So it is indeed a very good fortune for us that Dr. Bharat Suryawanshi has obliged to come on this session and be a part of this session. I welcome wholeheartedly Dr. Bharat Suryawanshi, sir, on behalf of S.S.T. College of Arts and Commerce. And I would request you to guide our students on the topic of patents, trademark, and copyrights. Over to you, sir.
Thank you. Thank you so much, ma'am, for introducing me. Good morning to all dear students and participants, faculties, professors, even principals, sir. Again, yes.
Sir, before you start, I would request you to tilt your laptop a little bit. It's gone in the side, sir.
Now it's okay?
Yes, sir. Yes, sir. Perfect, sir.
Okay. So I also welcome you all for the IPR session. As ma'am told, we know what is intellectual property, but we have to think how to protect our intellectuals. We are protecting our house, flat, plot, gold by putting the banks, but how to protect your intellectuals? Let us see in detail by sharing my slides. Are you able to see my screen? Anyone, please?
Yes, sir. It's visible, sir.
Yeah. So what is intellectual property? Question arises. So simply you can see my slides. I have shown something blooming or lightning in the mind. It means I want to convey that the product of mind is called intellectual property. Now, what is product? If you are writing books, it's an intellectual property in the form of copyright. If you are developing new technology, then again in the form of patent. If you are developing new brand, name, mark for your company or startup, again it's a trademark. Or you are developing some recipes, keeping secret, it's a trade secret. So any kind of idea that arises from your mind is called intellectual property. For example, you know petrol and diesels. You are having two-wheelers, four-wheelers going to petrol pumps. Day by day, we are seeing the rates are getting higher. So somebody among us or any scientist is thinking to give alternative solution for that problem as an biodiesel. So how the idea is coming? From your mind to give biodiesel. So for example, the process of production of biodiesel from my campus waste, it's an idea coming from your mind. Therefore, the product of mind is called intellectual property. Again, I'll quote another example that We know mosquito catching bats. Everyone is knowing because in Ulhasnagar, Kalyan, we know many mosquitoes are there. But knowingly, unknowingly, if I am putting that mosquito bat on, it gives small shock. We never bother elderly people, but children will cry for that. To solve that technical problem, I am being a computer fellow. I am giving digital mosquito catching bat. What is that? It recognizes human hand and it's never give shock to you. Therefore, solution to a technical problem. Again, the idea is coming from my mind. Therefore, the product of mind is called intellectual property. Let us see how that property arises. When you're in the classroom discussing with your professors regarding business, so somebody from your friends or sir together thinking to develop a business system for so and so, like Ola and Uber. What is that? Idea is coming from somebody's mind, so Ola Uber came. Netflix is a system, a device got patent for business method. Subscribing TV channels, giving service to them. It is a system. So idea earlier not there, now it's coming. So intellectual property, ideas coming from your mind when you are alone or in group of people or in the classroom or in the laboratory, wherever you are there, you are thinking to solve some problems and giving solution for that. Therefore, the product of mind is called intellectual property. Again, you know cancer disease. You know Mumbai Tata Cancer Hospital. How many people are taking chemotherapy, allotherapy, and how much side effects are there? So somebody from botany, biotechnology, or pharma coming with herbal medicine for cancer. Again, solution to a technical problem because you are giving new medicine which is don't have any side effects. So again, it's idea coming from your mind. Therefore, the product of mind is called intellectual property. Did you know? Ostley company has developed shoes, smart shoes. For whom? Blind people. For what? They cannot walk easily. Therefore, he has used an ultrasonic sensor so that blind people can detect obstacle up to 4 meters away. Means he can easily walk. What is there in the way he can see and he can make side. So it's a technology brought by someone to solve the technical problem or give solution to a blind people. Again, it's an intellectual property. Idea come from the mind of scientists or intellectuals of Australian company. Again, one of the professor from Nagpur has developed cold drinks from mawa flowers. You know, earlier Mahachapula means they used to make beverages, liquors, but now he has made cold drinks from that. What is that? Idea came from the mind of this intellectual person, Dr. PC, and given good cold drinks. So what is that? Invention, idea, patent from the mind of intellectuals. Again, tree climbing machine, washing machine, all the examples of scientists. You don't think that you are from cars, commerce, arts, invention can be done by anyone person. This is an uneducated fellow. This is a 14-year-old girl. So they have done the inventions. 9-year-old Adinath has done the invention. So Nimbore, 14-year boy, has developed electronic device which can tell you that you are getting heart attack. So science background is not essential to do the invention. Anyone can, any point of view, you can do the inventions. Let us see what is the background of property. The property means our mind directly goes to the tangible form of property. We say I'm car, flat, plot, I'm rich enough. But there is another kind of intellectual property called as intangible form of property. In that we are having industrial property and copyright. See, as ma'am told, different kind of IPRs, patent, design, trademark, copyright, trade secret, plant protection, all these are different kind of intellectual property rights. So let us see what is patent. Exclusive, monopoly privilege or right granted by the government to the patentee for 20 years from the date of filing or priority for commercial gain, not to keep as a file record to get in promotion. When you're disclosing everything clearly, then you're getting the patent for 20 years and it's a territorial right, not worldwide. Now, I'll take one example. You know, many shampoos you are using in your classroom or in your batch or even college, somebody may use just Vatika, somebody Sunslick, somebody Doe, somebody Mama. Recently, my family is using Wow shampoo. What is that? Are they really curing your dandruffs? No. Some heroes, heroines are giving advertisement in the TV. You are seeing that and using that. So are they really curing your dandruffs? Touch your heart and say, no. Simply, they are also smoothing the word. But if you are also somebody coming with new formulation or modified formulation for dandruff curing, that may be herbal or allopathy, you can also get patent, but you have to prove good results than the earlier Vatika shampoo or Sunslick or any other shampoo. So if you are providing good results, then you can get patent for that. You might have heard Haldi patent. What is that? You might have heard Basmati rice patent. What is that? Getting the right over the particular product, if it is new, novel, novelty lies are main for the inventions and technology to get an patent. So before that, many people are doing project. You are also become M.Com are also doing project. BSc also doing project. But while doing your research or a project, we should identify whether your research topic is qualifying the definition of patent or not. So let us see what qualifies. Patent means or invention means, or to qualify the definition of invention, you should have product or process. ATM machine. Before 2003, we don't have ATM machine. Now we are having. What is that product? Combination of software and hardware. Water washing machine, water purification machine, washing machine, fridge. What is that product? Process of preparation of medicine, process of preparation of a shampoo. What is that process? So it should be product or process. Useful to all, new, non-obvious. It should not be in the public knowledge before the filing date. Even if you want to publish your own article or a paper in any international journal, national, what you're doing? You are checking whether my research topic is published in national journal, international or not. If not, then only you are going for the publish. Same way, to qualify the definition of invention, it's a new product or process, useful, novel, and it should not be in the public knowledge. Then only you are qualifying for filing the patent. And you can file the patent, no one can stop you with respect to section 3 and 4 of the Patent Act. If you qualify that also, no one can stop you from getting the patent. So anyone can do the invention and they can get the patent. Simple sharpener. Earlier there is no sharpener when I was student. Now you know since LKG you are using the sharpener. It's an invention. Again in the school level, you have studied who has invented aeroplane, who has invented vaccines. We know Chandrayaan. All these are new because of human is the intelligent animal having power of thinking. So he's doing good inventions. Day by day, Covaxin, Covishield, Sputnik. What is that? Invention. The idea of bringing vaccines come from the mind of intellectuals. Earlier, when Corona came in 2018 or 19, we don't have any vaccine for the 19. In December 19, no vaccines, but scientists thought all over the world. In the middle of 2020, we got Covaxin, Covishield, Sputnik. What is that? Idea came from the mind of intellectuals to solve some problem. So any kind of problem, if you're solving, that's an intellectual property, which is in patent. You can get patent for mobiles, so software, you can get copyright. If you're developing electrical bulbs, LED bulbs, new improved bulbs, you can get patent. Even telephone, you got patent. Even mobile, you got patent. Nokia, Samsung, what is that? Improvement of technology from AG bulb to mobile. In this no video calling facility, I cannot take in the meeting. Therefore, we got the mobile phone. Video calling facility. Now we are having Google Meet, WebEx. What is this? Improvement. So I want to say you that getting patent is not difficult. If you are improving yourself in own technology, if you are physics, chemistry, biotech, micro, or any other common field, you can get patent for that. For example, during Ganpati, you saw recently in September, how many Ganpatis are there in the Mumbai? Every gully is having more than 10 Ganpatis. What you're doing? You're throwing in some pond, river, or lake. But in Mumbai, artificial lakes. But if you go to village towns, they're directly throwing in the natural river and lakes and pond. What they're doing? They're polluting whole aquatic life, water pollution because of malas, naividyam, modakam, all you are throwing that. So you're polluting that. Once government come to know, they throw some chemicals and they're destroying all food chain, food web, that's aquatic life. Somebody from you or any scientist develops herbal method for treatment of pond or river water. What is that? Idea coming from the mind to solve problem. So it's a patent because you are giving idea for that. So you're developing idea for that. So you can develop production of biogas from campus waste. Again, idea coming from your mind. So any technology if I bring, that is called patents, technology, vaccines. Nano car पहले था क्या? Hyundai था, Tata Motors था, Maruti Suzuki, Mahindra. Nano came in between. These are the examples of invention. Smart card, drones. These are examples separated. Let us see another kind of intellectual property, design. Design means anything which looks beautiful. Color combination in the form of 2D or 3D. I have taken Bajaj iron box. You can take Ketan fan, IB washing machine, LG fridge. You can check any design. Plus, brush, car, even handle design. If for engineer, you can check even handle is different from Hyundai to Mahindra, Tata. You can check carefully as a scientist. Mere how it works. Functional feature never counts design. How it looks. कैसे आंखों को दिखता है, that's a design. If it is beautiful, I can say beautiful design. Term is 10 years. It can extend for 5 years, total 15 years. Even set of articles, sofa set, chair set, spoon set, you can get registered in the government of India. Sanitizing machine recently got registered. See, these are the different kind of designs. Comb, brush, wallet, spectacle, watches, all the designs you can see different from Titan, Timex and all. Even curtain designs, bedsheet design, dress designs, earrings, bangles, all designs, if you're developing, you get registered in the government of India. Even daily consumer products, Coca-Cola, Mazda, Sprite, you are going for the parties, you are taking in the hand, but never think why the Coca-Cola bottle design is like this and why Sprite, because you are not thinking innovatively. The idea is not coming to your mind. You can check all got registered, therefore they're in the public or they're in the market. Again, you can say save configuration of the designs. You know this sharpener, dual in nature, peacock, facing pencil, Tom and Jerry toys, biscuits of Tom and Jerry facing, because children are saying Tom and Jerry nowadays, so they may ask the biscuits of same design because they're asking twice. So thinking that the marketing fellow are trying to bring such kind of eatables in the market. Again, cookies design, dress design, all these are different kind of designs. Another kind of intellectual property called layout of integrated circuit. We are using Taiwan, China chips. Why can't your own chips? Electrical and electronic people are knowing what are electronic chips. They are semiconductors, integrated circuit, and they can get registered in the government of India. And we can get term for 10 years. And you can sell to any company and you get the royalty out of that. I'm in lecture, please. I'm in lecture. Okay. 11 o'clock. So what is trademark? You know, visual name, symbol, brand. This is an example of trademark. Reliance, Tata, Biocon. These are the different kind of companies. Soaps, shampoos name, Vatika name, and the Ketan fan, Bajaj fan, all the names. So you are registered so that other company may not copy your name. If you sell that brand of Reliance, it takes crores of price because already it's called hold in the market. It advertises goods and services, protect the innocent public from buying the goods of second hand. R with N circle J, registered trademark. TM means you applied for the mark yet to get permission from the government of India. Duration is 10 years. It can be renewed for every 10 years subject to the usage. So Tata, Bata, how long they're in the market. So every 10 years they are paying the renewal fee so that no one can copy the technology. You can see some products are written RN circle means they got trademark. TM means you applied yet to get permission from the government of India. Once you're applying, it's go for examination, publication. You are issuing the report. You have to reply for that. Opposition may come. You have to deal with the opposition proceedings. Then finally, if you are able to satisfy all the grounds of opponent, then only you are getting your mark registered. That's called trademark TM RN circle. Otherwise, you cannot. You have to fulfill the requirement of opponent's grounds. As ma'am told, slogans also you can get registered. Yes, you can. A dil mange more. You can get registered. McDonald, Adidas, Columbia, Bureau of Indian Standards, Naukri.com, Google, all they got registered. Therefore, no one can copy their names. Another kind of intellectual property, geographical indication. These place names used to identify source of origin, quality, reputation, or other kinds of products like Darjeeling tea, Vaigauchi halad. These are the restaurant. Busawal banana, Nashik ki draksha. Term is 10 years. It can be renewed for every 10 years if you choose. Natural products like Makrana Malabar Rajasthan, Ratlamisyo, Kanchipuram silk sari, Chireli paintings, Bidri Ved of Bidar, Karnataka, Magai Pan, Devanalli Pamilo, Apimidi mango, Kashmiri saffron, Saheli Bihar, Kurg oranges. So even in the agricultural products, you can get natural products, you can get manufactured products, also you can get GI for that. Let us see what is copyright. Copyright is a bundle of rights, cover a lot of things. Provides holder right to restrict unauthorized copying and reproduction of an original expression, literary work, movie, music, painting. The term is life of the author plus 60 years. Therefore, many singers are no more, but still they are getting royalty for their songs. The books you might are referring for the commerce, arts, and all. The author may not be there, but you are paying means paying the royalty for that. Means you are buying from someone, indirectly the royalty goes to him. Now you can check if you are writing books, novels, stories, autobiographies, poems, any literary works, you can get registered under section 2 of the copyright. Artistic work under section 2C. Sound recordings 2H. Musical works 2P. Sound recordings 2XX. Cinematography under section 2. You might have seen Dedakka picture in Marathi. He has developed a device, he got patent for that, but he was not knowing his friend has registered that patent, and ultimately at the end of the movie he is getting crores of rupees for that particular product. You know, one of the movie Three Idiots, that scientist hero is having 427 patent on his name. He is the scientist and he is the everything for that. Again, you know, one of the movie Sham Sundar Roy, it is Telugu movie dubbed in Hindi. That is speaking about the infringement of copyright. Some stories have been copyrighted out. You can check, see that movie, that you can see in that infringement of copyright, importance of copyright. So we speak about dub. Telugu का movie Hindi में dub हुआ, Kannada movie this में dub हुआ. What is the dubbing and all? Copying of the dialogues, copying of the story, copying of the sound, something like that, and they are dubbing in this. So many cases are there in the court infringement of copyright, but you know, Indian courts giving result is late, so we don't feel much important. But movie aega chalega, you are, they are earning their own benefit, so we don't think much important. But still many cases are in the court for infringement of copyright. Again, we should know what type of work, who is the author for that. Literary dramatic work, author who creates the work is the author for that. Music work, composer who is composing that, he is the owner of that. Artistic work, other than the photograph, artist who creates that. Photograph, person who is taking photograph of that. Cinematograph, film or sound recording producer is the owner of that. Literary, dramatic, artistic or computer generated, the person who causes the work to be created is responsible. The government fees for filing copyright work as a literary, dramatic, artistic, musical, 500 per work. If you are doing artistic work, filing 2000 per work. Sound recordings 2000 per work. Cinematography films 5000 per work. So each kind of work you can get in protection in the government of India. Again, some inventions which cannot be protected by patent, design, trademark, so they kept as a trade secret. Like we are drinking Coca-Cola, Mazda, but we don't know the formula of that till today because they are maintaining as a trade secrets. Again, if any new plant varieties, if you are producing, if they are novelty, distinctness, uniformity, and they have stability throughout there, then definitely they can be registered by breeders, farmers, universities, agriculture. Institution can also. Term is 15 years for annual crops, 18 years for the trees and vines. You are having rights for plant breeders. You can see it. Farmers' right is also there. You can show, resow, exchange all the seeds which are not branded or proprietary material. They were having researchers, right? Means any research can use any product variety for plant for research or production more or doing modification of that. No one can stop you from using that. You can see simple example. I have taken laptop of Apple. By knowing this, will come to know. So they got protection as a trademark. Overall, as a design they got. Again, LED display. After putting inputs, we are getting display. What is that technology? They can get patent. Inside that circuit, layout of it, you can get. So my aim is to say that you can protect your single product with more than one IPR so that other company never copy your technology. As you can see, the formulation of Coke, we don't know what is the content of this. So that's a trade secret. This name Coca-Cola in this fashion, they got trademark. No one can use this name. Shape of the bottle, small, bada, then small again. This is a design of that. No one can copy. Coca-Cola bottle is different. Mazda bottle is different. Sprite bottle is different. Even beer bottle is different. Patents, the instrument or a device from which I am making the bottle is a technology we can get patent for that. Text, database, artistic work appearing on this bottle is a copyright. So no one can copy the technology. So single bottle, I am protected more than one IPR so that no one can copy the content of Coca-Cola, brand name of Coca-Cola, design of Coca-Cola, even copyright of Coca-Cola. So please, if you are also developing any technology, go for the protection and get it protected so that no one will be the competitor for you in the market. Alone, you can play in the market like Coca-Cola, Mazda, and Sprite. You can check your mobiles, Nokia, Samsung, Oppo, Reliance, Apple, everyone is having. They all got protection. Therefore, they are in the market. No one can copy the technology. The public whom want to Nokia, they will take Nokia. Samsung, they'll take Samsung. Those are more money, they can Apple. So depend upon the condition, they can take the different kind of mobiles. Now, what are the career opportunity for the students who are eligible? If you want to come in the government of India as an examiner of patents and design, you should have qualification of MSc Chemistry, Biotechnology, Microbiology, Physics, or any branch of B, depend upon the vacancy and advertisement. There are two papers, one is objective and a descriptive. Qualify, YOC, then you will be selected as a government officer, as an examiner of patent and design. If you want to come as an examiner of trademark, GR, copyright, you should have a law background. Then definitely you can apply to the UPC and you'll be selected depending upon the vibe. If you want to work as a trademark agent, any law graduate or your commerce arts graduate can also, but they have to pass the trademark agent examination. Every year we are conducting. If you want to patent agent, any science graduate can become patent agent. If you are having knowledge of IPR, you can work in the IPR policy, IPR cell, NGOs, even IPR firms. You can work. There are many IPR firms in Mumbai. You can check in the Google. I cannot take the name of that being a government servant. So you can check. There are many IPR firms you can work with that. Now, as I told you, you may be scientists. Many invention you might have done. Faculty, students, but you are not inventor. Inventor means the person who is doing something new, filing patent and getting reward on that. So they are called as an inventor. So you may not be inventor. You may be doctorate, awarded many PhDs, but you may be not an inventor. So if you want to be inventor, by simple approach you can. No science is required. No arts. Anyone can do the invention. While carrying out research project, identify some problem in and around you. Solve that problem, you can get patent for that. For example, I'm bringing herbal medicine for skin. There was a problem, I'm bringing herbal medicine. Or SMS alert to a farmer when wild animals are entering his field. So I'm giving alert to him so they can run away, he can go and protect his field. Invention. Again, smart scan for the blind people. I'm bringing stick which is smart, which can take the obstacles. Again, technology. Smart shoes for the children and adults. What is that smart shoes? I'm putting tracker software. If you put tap on that, you will get location on registered mobile number. So somebody kidnap, your children is kidnapped from school or anywhere else, or elderly people are kidnapping. If they press on the button of that shoes, you will get the location where he has been located. What is that? Invention. One of the professor has developed smart ATM machine. Means only machine is there, no need to use the card. If you put the finger, you are getting the money out of that machine. So these are many technology cutting. So any problem if you're solving, you can get patent for that. any problem. You can bring shampoo, you can bring detergent, you can bring medicine, you can bring device, machines, shoes, anything if you are bringing, you can get patent for that if it is a product or process, if it is new novelty. Now, what is patentable in India? पेटेंट में क्या होता है इंडिया में? लाइक प्रोसेस और प्रोडक्ट को इंडिया में पेटेंट मिलता है, कोई प्रोसेस ऑफ प्रोडक्शन ऑफ बिवरेजेस मिलेगा, प्रोसेस ऑफ प्रोडक्शन ऑफ मेडिसिन मिलेगा, प्रोडक्ट एटीएम मशीन मिलेगा, सिटी स्कैन मशीन मिलेगा, सो एनी प्रोडक्ट यू कैन गेट, हर्बल कंपोजिशन मिलेगा. It should be new, having inventive step. What is that? We will see again, capable of industrial application. ये तीन चीजें qualify हो तो definitely we are getting the patent. And section 3 and 4, which is non-patentable invention, like method of treatment, plant assets, animal assets, frivolous invention, method of presentation, not patentable, software assets, not patentable. So you can check section 3 and 4. It is in detail. It takes one day to explain you all what is non-patentable invention. So which should not attract that. And if you are qualifying this novelty in your check, we are getting patent for that. Product includes apparatus, device, machines, and chemical products. You can get patent for all. Now, when we can say that your invention, your product or a process is new or not, it should not be published in India or elsewhere. It means throughout the world we are checking for the novelty. It should be new in the world. It should not be in the prior public knowledge or prior public use within India. Again, it should not be claimed before any specification, means any application in India or elsewhere. It's not only India, throughout the world I am checking for the novelty. If you are bringing new jug, then this jug should be not only India, throughout the world it should be new. Then you are getting qualified the definition of novelty. Another is invention. What is that? Feature of invention that involves technical advancement as compared to the existing knowledge. For example, AG bell to mobile phone. What is this step? Technical advancement. Having economic significance. Earlier, you know, simple Nokia mobile in the year 2004-3 more than 5,000 rupees. Now 1,000, 2,000 up to 40. What is this? Economic significance or both. That makes invention not obvious to a person skill in that. What is obviousness? For example, I'll give an example for obviousness. हम बातें करते बोलते, it's very obvious to do. But what is that obviousness? Let us see. For example, I'm making tea. So how I'm writing in the patent application? Because patent is an techno-legal document. Technology, we have to describe in terms of legal. So we are getting the protection for that. For example, process of making tea. Maharashtrian fellow is preparing tea. Process of making tea comprising steps of A, comma, taking cup of water, comma, step B, taking cup of milk, allowing it to boil, adding pinch of tea powder and sugar as per the taste and boiling. Step C, filtering. My tea is ready. Second claim. The process as claim wherein one of the ingredient to enhance the tea, I am adding kavlacha mulya, that is roots of some medicinal plant, or gauticha to my tea. This is Maharashtrian style tea. Somebody from Karnataka is also making the tea. Same process, but he is adding ginger for the tea. Instead of kavlacha mulya, gauticha, he is adding ginger for that. Somebody from Gujarat is also making the tea. Same process, but he is adding cardamom, elaichi for the tea. Somebody from Telangana or Andhra coming for the international conference in Karnataka, Maharashtra and Gujarat, he tested all the 3 teas. So it's very obvious to him to prepare the tea by using kavlacha mulya, gauticha, adrak and elaichi. So it's very obvious. So to get the patent, it should not be obvious. Obvious nahi hona chahiye, then you are getting patent for that. It should have some experimentation. Now, who is the person skilled in that? For example, I am filing patent for biodiesel. Then person who is chemistry, biotechnology is a person skilled in the art. I am filing patent for electronic device. Any person who is having electronics knowledge is a person skilled in the art. I am filing patent for a device. Any mechanical person who is skilled in that. So the person who is knowledge of particular field is called as a person skilled in that. So it should not look obvious to then you are qualifying the definition of inventive step, like getting surprising result, solution to long-standing problem if you are doing, fulfilled of a long felt need. Since long back, we were needed solar panels, but now we are getting. Since long back, I was needed conversion of wind energy to electrical, no, but now we are doing great technical progress like covaxin, covaxin. Within, if you are doing something great, you are getting patent for that. You are qualifying the definition of inventive step. Last equivalent, it should be made or used in the industry. So these are about the patent, how to do new research, how to bring your idea into research, and how to protect that, how to qualify novelty in step, and how to get patent for that. While writing the application for patent, you should have title and preamble. Process of preparation of herbal medicine for so and so, title. Object, allopathy is very side effect. Chemo is side effect, so I'm giving herbal medicine. This is my objective. What is there in the prior art means literature survey. What were drawback in that? How you are doing good? What is summary of that? Detailed invention, drawings, sequence if your biological inventions, plant, then plant version from where it is, NBA permission you have to apply, detailed description with the drawings, all you have to do, examples, and finally you have to claims for what you want protection. What is not claim, that is disclaim, you will never claim. So please keep in mind that how much you are able to cover, please claim what you want protection for that. As I have claimed a agriculture machine, so I have given this machine, I'm claiming, so all the parts have been given. I'm claiming compound drug, a compound of formula so and so, it's an Pfizer patent application. I'm claiming process of making so and so medicine, you can get that patent. Again, composition, medicine, lotion, you can get a composition comprising azolistine, salt thereof for ocular, nasal solution, nasal spray, nasal drops, solution, powder, all the form of that drug I am claiming because no one come with the other products. So this is the way of claiming the product patent in India. Now let us see how to file your patent application in India and who can file. Any person, startup, MSME, anyone can file the patent application. There is no age bar limit nor educational limit. As I told you, no education counts. Educated, uneducated, art, science, commerce, anyone can do the invention. So you are being commerce, being arts, don't think that. If you are having any idea, please come up with that.
Dr. Bharat, sir.
Yes.
Sir, in the last slide, you have shown about the C plus product related to nasal ocular, that is
Yes.
for nose as well as for ears.
Yes.
Sir, the previous slide which was been shown, and you spoke about the steroids, the esters, the formula which has been claimed, the application was done by CIPLA, and the claims what they had given as per the drawbacks as well as the way in which they had filed the application for patents. So in the patent office also there are pharmaceutical scientists also, they do counterattack with the CIPLAs or any pharmaceutical industries the claims what you have done, how the patents are being granted for the pharma products.
Yeah.
Or yeah, sir, because when the pharma companies are launching any product like we have Covaxin or Covishield, then when we apply for the patent, so there in the patent office also there is a doctorate in pharmaceutical science, or how they counterattack.
Yes.
So
So all
because
the people are, see, there are different branches, electricals, mechanical, civil, electronics, all people are having with us. We have been trained in different field how to judge novelty in stuff. For example, you are filing the composition of azolistine. So we are having database which are free also and paid database. In that, we put some search strategy, how they are trained to us. We search azolistine, salt for nasal ocular. If you are getting any relevant document, we study that. If you are having earlier invention in the same manner, then we object that already so and so document is speaking about the azolistine and salt for nasal or ocular use. So it's not now it. We put the objection and we send you the report that is called first examiner report. Then you have to reply, no, this is an azolistine for so and so, mine is like this. This result is having only 90% purity, mine is 99 purity. So you have to prove how it is best than the earlier product. Then we are able to satisfy, then we overcome the objection. Otherwise, we maintain the objection and we reject your drug.
okay, sir. Okay.
Again, for the inventive step, we put one or two documents. Novelty, single document sufficient. For inventive step, you require more than two documents, more than one document. Then, in view of D1 and D2, any person who is having knowledge of pharma can come with this solution. So it's an obvious. We put the objection. Then you have to explain us how you cannot arrive at that. Then we can make way of the option of invention. Otherwise, we maintain that. Again, we put the option of 3. It's just mere admixture of 2 drugs. Then you have to overcome. No, it's showing some therapeutic efficacy. We have to prove. Then we'll come. We'll put again objection of 3D. It's a not a novel drug. Then you have to overcome. No, it's not in the prior art, not in the latest survey. It's new. Then we'll check. Then if you are able to prove all the grounds of FER, then only we are granting the patent. Otherwise, no.
So is there any chance whether this the lawyers from the CIPLA or any of the pharmaceutical company asked to do the amendment in the Act of the
Yes.
patent? So yeah.
See, earlier in before 2005, we are not having product patent in the pharma. We used to get only process. But to meet the requirement of TRIPS agreement, we have signed the product patent. Since then, we are granting the product like composition and mixture. Earlier, only process patent were there. You can check. We used to call them as a mailbox application in 2005. That is opened after 2005, and we have granted the many products patent.
Okay, sir. Okay, sir. Continue, sir.
Yeah. So I was with the filing. So anyone can file the patent application. There is no age bar limit nor educational limit. We can directly go to Mumbai office. As you are from Maharashtra, you can file, or online filing facility is also given. Different jurisdiction given in the website. Please see carefully. For example, Chennai. Chennai covers state of Andhra Pradesh, Karnataka, Kerala, Tamil Nadu, all southern state. Maharashtra, Mumbai covers Gujarat, Madhya Pradesh, Goa, Chhattisgarh, even it is a Daman. So these are the jurisdictions you are supposed to file there only. Examination can be carried out anywhere else, but filing should be to depend upon the jurisdiction. As Form 1 is required for applicants all details. In that paragraph, 12 has to sign by all the inventors to sign that is called proof of right. Form 2 is required for filing the patent application. Form 3 for foreign filing. If you are same technology filing the foreign countries, you have to mention that. Which country, what is status of that. Form 5 to add your friend's name as an inventor. Form 18 request for examination. Fees, as you can see in the website, already given on the website, 1,600 for natural person, 8,000 for others, up to 30 pages. Per page, per claims after 10, it increases. Please see carefully while you are filing the patent application. You are having chance to file expedite examination as per Rule 24B. Those for filing PCT application and choosing India as an ISA. ISA means International Searching Authority. IPM means International Preliminary Exam Authority. Means you are filing the patent, we search, we give the report whether it is patentable or not. That is called ISA and IPM. Or applicant is startup, or as per 2019 rule, one of the applicant in your group should be ladies, then you can apply, or government organization or institute can also. Fees for Form 18 is 8,000 per individual, 60,000 for the others. You can check our websites for patents, designs, trademark, GR. If you want to file online, comprehensive e-filing, you should have e-signature or digital for patent, design only digital, trademark only digital. For copyright, no need of any signature. Just log in, create your ID password, fill the form, upload the document, pay the fees. Then you are filing your copyright application. As sir asked about the granting the patents, I'll go with this and then I'll conclude. Once you're filing the patent application physically in writing, then we digitize that. If you're filing online, we take the data online only. Then we screen and classify which subject is, biotech, micro, physics, electrical, which it is. And classification we are using international patent classification, that is called IPC 7. If you are requesting for early publishing, we publish within week or a month, otherwise 18-month publication. Once published, anyone can oppose, that is called pre-grant opposition. There are grounds under section 25(1) of the Patent Act. You can come up with any ground, file pre-grant opposition, we deal with that. If you are requesting for examination, we are carrying out examination within, we allot to the examiner and controller. Examiner carry out formal technical objection. They make the list, they forward to the controller. Controller again modify, delete, add the objection, make final list and send to the applicant or applicant agent, means lawyer or attorney. Then they have to reply within 6 months. If you are unable to reply, they can take extension of 3 months for filing Form 4. Again, 3 months extension. Within 9 months, by hook or crook, you have to file the reply. If reply is okay, persuasive, we are granting the patent. Otherwise, you are getting chance of hearing like a court hearing across the table, online or offline. Since Corona, we are doing online also. So you have to make satisfy that all the grounds what you are raised in the FER to overcome. If you are able to overcome, we are granting. Otherwise, we are rejecting. If you are granting or rejecting, we give the speaking order. You can go to the High Court or Supreme Court. Once granted, it's go for the publication. That is called post-grant publication. In that, once opposition comes, we constitute opposition board inside the office. There are 3 officers, one is chairman, 2 are the member of that board. They give recommendation on the opposition board. Then if the recommendation given, then opponent or applicant request for the hearing, we conduct the post-hearing. Simultaneously, all the opponent's grounds we are forward to the applicant. Applicant will give detailed reply on that each ground. Reply issue from the applicant, again we are giving to the applicant. If anyone requests for the hearing, we conduct post-grant hearing date. In that, applicant, their lawyer's agent, opponent, their lawyer agent will appear in the room, like hearing room, and we are the deciding authority. Each ground of opponent are discussed with the applicant. If is able to overcome, we are granting the patent, otherwise we are rejecting the patent. So we are giving decision for that. You can appeal in the High Court or Supreme. This is the way of granting the patents. Thank you. Any questions? We'll have the discussion now. Please share the feedback link in the chat box.
Yes, sir. Yes, sir. Sir, since we are also in the process of going for the patents for in our family, we are starting with our homeopathic plant. So, is there you are getting the application for the homeopathic medicines, because you spoke about the agriculture, sorry, the herbal drugs. So, do you get the application for homeopathy, and how do you counterattack with the claims which are being made by them?
For example, if you are claiming to
I'm giving an example of, sorry to sir to disturb you. There is a one company called Baxon who
Paxson,
comes Baxon. Baxon comes out with the homeopathic drugs. So there are many companies who are like in the New Bombay or in Maryland. There are many companies who are coming out with the homeopathic drugs. So how the application is being taken up, and how they you counterclaim their rejection if it is
yeah.
their
Still at present, I never come across, but I seen the filing of the homeopathic application for the treatment of cancer and all. So the
Okay.
name of medicine what you are giving,
Mhm.
that content we check in the search, that is paid database, that is called PAT sheet or total patent. These are the 2 database which are paid. Free we are having WIPO, USP2, EPO, Indian also. But we check, being a authority of the government of India, we check in the PAT sheet and total patent one. We search what is the content of your medicine, that may be homeopathy or any kind of medicine.
Okay.
And what is the effect you are showing in that combination of true, how much effort you are giving, the tincture of one having so and so composition, tincture to a so and so, combining effect, how much you are giving, that you have to prove in the form of efficacy.
Sir, you have done the PhD in the efficacy
Pharma,
of pharma
medicinal
medicine.
chemistry.
Yeah, sir, I have seen, I've gone through your profile. So, sir, is there any application for the pseudo drugs which are coming out, or they do apply for pseudo drugs, or the placebo treatment? They
Yes,
do apply
yeah.
placebo treatments. Yeah.
So you can file any composition for any type of treatment. Only method of treatment as such, directly if you are claiming, we are not giving patent.
Okay.
Process of treating, again, we are not giving patent. But composition comprising 2 medicinal plants or 3, 4, you can file the patent. That is in form of composition. You can
Okay.
get patent for that.
Okay. Sir,
Simultaneously, the plant what you are using, you have to mention from where you are using, and you have to take the NBA permission from the Chennai. Then definitely no one can stop you if you are able to satisfy the requirement of section 3E and 3D. Both are the requirement of that. Because mere admixture is not patentable. If I am taking in Corona, you heard Kada Pio, Kada Pio. What is that?
okay.
Kada is the extract of all the medicinal plants like ginger, tulsi, and many other spices.
Yeah.
So what ginger does, what spices does, what vinca roja does, what other does, by combining how much you are able to show the efficacy. That is must. But giving only ginger, how much time it takes to reduce your respiratory tract infection. By using spices like cardamom, how much it takes. Combining how much effect is there, you have to prove that. That is called therapeutic efficacy. If you are able to prove, no one can stop you from getting the patent. In cancer drug, what happened? The company has failed to prove that efficacy, so therefore it has been rejected. So you can able to show combined effect. definitely no one can stop you if it is
Once,
any kind of formulation.
sir, once it has been refused, and the within how many months they can file an application so that you will give the opportunity to be heard to the company.
Yeah, see, once we are opposing, then you can file review decision under section 77F. You can file, sir, you are wrong in the refusing. Please revise your decision. Then again, we think of that because you may give some grounds that my drug is new. So again, you can request under section 77F for reviving the decision of controller decision. So if you are rejecting, also you can revive our decision.
Sir, the next question. So the next question, which has been received from our one of the colleague. Sir, how can you identify that this is a patent product? Is there any identification mark? Because in this slide, what was being shown by you in the 77 slide, 73 slide, and 68, you rightly explained about the TM, the R, the C. Sir, how to identify whether it is a patent product? I'm giving an example like Cafe Coffee Day or Barista, where they used to manufacture or sell the cappuccino coffee, or there are different types of coffee which are being sold at the outlets at the airports. So how can you identify whether it is a patent drug?
Yeah, for patents there is no as a symbol.
Okay, no symbol.
So, right, no symbol for that. The company who is having the patent, the certificates with them. Somebody using without their notice, then only they can sue them in the court. Otherwise, they cannot stop you from using or infringing their patent. They should come to know. One of the example happened. One of the nut bolt company got the patent for the design of their parts of the mechanical parts, and same part they used to export to the Chennai area, means South area. After 4 years, the order from the South is completely stopped. Then this owner of the company surprised to know how he might have started. He is the regular customer of me. Then after 4 years, by changing his all the look, he went to that company with address where he used to supply his product. There, they have copied his design, what is the register, technology by mere modification, and they are manufacturing themselves only. Then he has given the notice to them. Then they told, please don't go to the court. We pay you 50% of the royalty what you have got from the 4 years sold market. Without doing any effort, simply because of patent certificate, they have saved him 50% of the benefit to the person who is having the patent. That is, we can do up to 20 years only. After that, it is the public domain. Okay, so this is a way of infringement, but we cannot see this got patent or not. We should know by knowing. For example, many detergent composition, Hindustan Unilever got patent for that. Many food products got patent by Hindustan Unilever. Ranbaxy got many patent. Mahape company of Sun Pharma got many patent for eye drops and many medicine house. So we cannot write like P and circle like that. Trademark we are having, but patent as such we cannot.
Sir, what is the
copyright also we are having? Copyright we wrote C. You know, C with an circle they are writing for the copyright.
Copyright, sir. Sir, what is the maximum and minimum penalty for the infringement of the patent product? Like, sir, we had long back when I was a student, there was a product called Rantec. Then it was been sold by at around 300 rupees. Now it has been sold for 3 rupees. So if any product like Covaxin or Covishield or any of the patent product, like as you said about the HIV drugs or the drugs related to cancer for the skin, if the person is also wearing same drug and manufacturing syringe with the same composition, and if the complaint comes to IPO office, so what are the penalties related to them, maximum, minimum, whether it is a civil offense, and what are the how do you claim that is an infringement of copyright patents?
Yes. Yeah. See, all with infringement is taken place in the court only. We are supposed to go to your high court for the infringement of their patents. There, they decide the penalty depend upon the how much you are able to infringement on that. Its court will decide how much penalty they have to put. So directly the matter goes to court, not to the IPO.
Sir, coming to the same point what you said, regarding the courts, sir, as you are aware, whether it will be only the High Court has the jurisdiction or any of the court which has been specially established as the jurisdiction.
At present in Mumbai High Court, but in for litigation cases in Delhi, they have been established special IP courts now. Justice Pratibha Singh is the looking after all those things. Many branches have opened. Earlier, all common, but in Mumbai, we are going directly for the High Court for trademark infringement, copyright infringement, or patent. Even Mumbai, many cases are there because whenever the case comes, sometimes our official has to go to define the case. or to know, identify how much they are infringing and all that. So all comes evaluation of the patent. So in the branch of people or advocate or people who are sitting in the market, they evaluate your patent. So how much violation, how much he has copied, that they will decide. The court will decide how much penalty they have to put on your particular for the infringement of the patent. For example, you are copying one or two ingredient of the product. So how much that? Or whole you are copying, whole ingredients, that also count. By mere changing the composition also never much result in the differentiation. So they will check how much you are infringing the patent, whether fully infringing or some part of the ingredients you are copying out. That all counts a lot.
Sir, one of the students from Department of Management Studies has raised the question related to passing off. Could you say in few lines what do you mean by passing off in context with Patents Act?
The passing off is with respect to the trademark only. See what happened. Just a minute. Passing is off with the trademark.
Yeah, sir. It is related to trademark. So that means I'm giving the rights to the some other person for
That
the
is
limited and
illegal sale of one's product. That's another. Means somebody is having the product illegally. He's selling that product.
okay.
And he's enforcing the registered trademark like that only. So the thought of passing off protect the goodwill of a trademark misinformation. Means you can go to the court and you can protect your mark for that. So somebody is using your protected mark and selling in the market. That is called passing off the trademark. Yes, 5 minutes.
Sir, sir, one of the student, one of the faculty and the students are asking the question, if they are preparing a research paper and a research paper is being published in a Scopus or any of the journal, whether it is published in any of the article. So as a student and which is new in the IPR, which is the best way where he has to apply, whether he has to apply for the copyright or he has to apply for the patents or anything.
See,
Yeah.
please put up here. Please don't. For example, if a research patent is a product or process or technology, directly apply for the patent. If research is for the mere data, presentation, or anything else, you can go for the copyright. So
Okay.
depending upon what patent is related to. For example, I am doing research. I am presenting paper on herbal composition for jaundice. So I have to obviously I have to go for the patent.
Okay. Sir,
and if I am, for example, I am doing studies on psychological survey of the people who are behaving like this. So that's a data presentation. You have to go out to copyright only because you cannot get patent for the psychological behavior models and all. So you have to go for the copyright only. So depend upon what kind of paper is you are from physics, chemistry, or scientific paper, or mere data collection. Depend upon that.
Sir, I had seen the journey of your office, the Nagpur office from last 3 years. There is an awareness campaign which has been run by your group in Maharashtra. Whether same type of group has been run in all over India or it is only restricted to Maharashtra, because the UGC guidelines says that there should be awareness related to IPR. Whether
It is throughout the India. It is throughout the India. We are using NIPM program to make aware because all the institutions are teaching more to the students. So all the technologies, designs, copyright matters are developing from the teaching institute only. Therefore, we are keeping more concentrate on the teaching institute. In China, USA, what they are doing? Most of the invention from college only. Therefore, we are focused on colleges to make aware how to file design, if it is design, how to identify your design or copyright patent. So that all will be dealt throughout the country. So you can pass this message to all the people who are knowing other state also. We can conduct the program for them also.
Okay, sir. In this slide number 77, you spoke about the trade secret also, which is coming out one of the IPR, and you spoke about the industrial design also. So when we were the students, we had only 4 things: copyright, trademark, patents, and design. Now the IPO office gets n number of applications. Could you give me some best example where the new one is been introduced? That is my last question.
Which exam? New one for what? Trade secret.
No, sir. See, when we had in IPR, we had trademark, copyright, patents, and design. Now you are getting the application for trade secret. Is there any new one where the people are applying under the category of IPR?
Yeah. Usually for trade secret, they don't come to our office.
Okay.
Formally, they are keeping secret. Their product directly come in the market.
What about GI, sir?
GI, they are filing. GI is, now only one of the agent fellow, practical fellow, Ganesh Hingmere from Pune has filed 51 GI in India. 51 GI alone fellow. He's going each corner of our village. For example, uh, mm, tamarind of Panchunchali. Panchunchali is very near to my village, just 35-kilometer village. He reached up to that place. I saw yesterday in his application list, he has filed tamarind from that area, which is of 1 meter length of the tamarind. We are not aware that he has found that. Again, borsuri dal. Borsuri dal is the recipe of dal. I don't know the taste of the water of that borsuri. Village is making more effort around, which is very, even non-veg is fail in front of that dal. So he is filing the recipe of that also now. So
Thank
means any geographical location is enhancing the taste of the particular product, you can file the GI. Sandalwood of the one of the this Gadchurli village, yesterday he has filed one patent. राम मंदिर जिसमें बनाया है उसके लिए पूरा सैंडलवुड यहाँ से गया है, तो उसके लिए टीक वुड, तो उस वो कल इंटरनेशनल कॉन्फ्रेंस था एमएनएलयू महाराष्ट्र में, तो वहां पे ऑनलाइन उन्होंने डिस्क्लोज किया कि हम ये पेटेंट ये जीआई फाइल कर रहे हैं. और एक आदिवासी लोग है मोवा मोवा बोल के कुछ यूज करते वो लोग, पहले के पाड़ा के लोग, पाड़ा मीन्स यू नो आदिवासी, बिफोर गोइंग टू डिलीवरी दैट बाई यूज टू अप्लाई ऑन द हैंड्स. व्हाट इज दैट? सैनिटाइजेशन. तो उसके लिए वो जीआई फाइल किया है उन्होंने. सी हाउ मच मीन्स पहले के लोग डिलीवरी करते टाइम हाथ से करना है तो ग्लोव्स नहीं था, दे यूज्ड टू अप्लाई दैट प्लांट प्रोडक्ट्स एंड दे यूज्ड टू गो फॉर डिलीवरी. वो उस कॉन्फ्रेंस में मुझे सीखने मिला. मीन्स पीपल आर हैविंग मोर नॉलेज, we are not touch with, we are not going to the padas and all. They are having many Ayurvedic medicine, but you are not going to them to understand that and file. No one is mediator for them. So it is NGO work to go and each pada, know their medicinal importance, what they are using, how they are working, and all you have to do.
Dr. Suryawanshi, yeah, sir. You are rightly explained for the delivery. The people used to apply something on their hands before going for delivery, and this type of application is new. So that I can also give this type of examples.
Yes, you can get GI because that plant product is originated from your particular area. So it's GI. You can apply for the GI.
With this, I would like to thank the management of our college, Dr. J.C. Purswani, the founder principal, the IQC coordinator, Dr. Khushbu Purswani, my colleague, Dr. Padma Deshpande from the head of department from the Department of Management Studies, myself, assistant professor, with the colleague with me who is Assistant Professor Deepak Malpani, who is supporting us for organizing such session. And sir, you have made clear the concept of patents, and I hope with this session more and more students and the faculty would be taking the benefit. Students, the feedback link would be open till tomorrow, and you have to fill up the feedback form. Then only the certificate will be given to you on your registered email address. Thank you from my side. With this, I'm declaring this session is over. Thank you.